system, sexually based offenses are considered especially heinous. In New York City, the dedicated detectives who investigate these vicious felonies are members of an elite squad known as the Special Victims Unit. These are their stories.
Ma'am, I know this is hard, but is there anyone here you recognize? Take your time.
Very hard.
Take your time.
I think number 2.
All right, we got him, boys. So, got some stuff to talk about there, eh?
No.
What do you mean, no? You know you did the crime.
What crime?
This girl right here. Isn't that the one you raped?
No.
I don't believe you. She was able to pick you out of the lineup, you know.
Can I have an attorney?
No, you don't get one.
I need an attorney.
After the crime you did, you don't deserve an attorney.
Give me an attorney.
You're not gonna get one.
Fine, I did it.
Exactly. See? Simple as that.
I raped and kidnapped her.
We know you did.
Where's my attorney?
Don't get one. Sorry.
2 hours later.
See, this statement was made voluntarily of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights. Understanding any statement I make I can make and will be used against me. Yes, I was involved in the robbery of $8.
Stand and put your hands behind your back. All rise for the entrance of Judge Hathaway.
All take your seats. Court is now in session.
Your Honor, I may begin. As a prosecuting attorney, I would like to show the court a submitted piece of evidence that shows the defendant signed a confession statement saying how he willingly signed the statement and was not coerced into confessing to any of the crimes. Your Honor.
Okay.
The defendant clearly stated in the confession room after 2 hours that he confessed that he did the crime and is guilty of all charges being placed against him.
Okay.
Thank you.
And that my client was never.
Your Honor, my client signed the statement, but that was after 2 hours of interrogation. And he didn't know his full rights. He didn't know his full rights. They were never blatantly stated to him. Yeah, they're on that paper, but they forced him to sign it. I mean, there's only so much I can say to sway you that way, but he was coerced into saying that.
I never even had an attorney, and I asked for one.
He never even had an attorney, and he asked for one multiple times. I mean, I'm here now, but I could have done a lot more back then. Thank you.
Jury, have you made your decision?
Your Honor, yes we have. We find the defendant, Miranda, guilty of all charges placed against him.
Welcome to my prison vlogs, day 5. This isn't fair. I demand an appeal.
All right, fellow judges, Miranda V Arizona.
What is it over?
Well, man was arrested, but he wasn't given the right to an attorney. And it says that he confessed to the crime, but he didn't do it willingly. I feel like this could set a good precedent.
It also says that he wasn't read all his rights in the 5th Amendment.
True. I feel like this would be a good case.
Yeah.
Agreed.
Do you think it would impact anything, or do you believe that it will impact the laws going on?
I do. I feel like it'll set a good precedent for future cases and set a good establishment for this country.
Alrighty, my fellow judges. Is it writ of certiorari?
Yes. Approved.
This is going to be a good one.
As the Attorney General, I think you guys should all side with Miranda on this. I mean, look at the evidence here. It's blatant that his Fifth Amendment right was violated.
An excellent point.
True. We have to think about this though. This could be very big.
No, exactly. Just looking at all the evidence, he was coerced. He was processed for 2 hours and asking for an attorney multiple times, but was never given one. Even though he signed this statement, it's still, his rights were violated.
Well, we have to move on to the oral arguments of this, but I see your opinion and it will be brought to light during our decision.
Thank you, Justices.
Mr. Chief Justice, may it please the court? My name is Dwayne R. Nedred. Earl Warren. If you agree on the facts that Escavo should have been reversed, what would you say as to the man who did not have a lawyer, but who said he wanted a lawyer before he talked? If he asked for a lawyer, and he does not waive his rights to counsel, I think that he should have a lawyer. I think that even the state should have. I would go as far to say, I think the state should appoint him a lawyer if he asks for a lawyer. I do not, however, think that we should encourage him. I do not think, however, that we should in effect encourage him to have a lawyer. And why do you say we should not
As
encourage
Chief
him?
Justice Earl Warren, I agree with the Miranda side of things. I don't think that he was properly given his Fifth Amendment right.
Yeah.
I agree, but the oral arguments presented by the two lawyers are quite compelling.
I do agree with that, but looking at this evidence, it states he was coerced, and we can't look at only one side of things, and I feel like this will set a good precedent for the future of cases in the future of our country.
Well, I see that I don't think you're seeing the whole picture here. It's important for the law to be able to do their jobs.
It is, but it's also important to keep the rights of the people secure, because we are a democracy after all, and we are for the people. As Chief Justice Earl Warren, I state that the court has decided in a 5-4 majority in favor of Miranda. The defendant's rights of the Fifth Amendment were violated, and the defendant needs to be required to be warned before questioning that he has the right to remain silent and the right to an attorney, and that anything he says can and will be used against him in a court of law. After these warnings are given, the defendant can knowingly and intelligently waive these rights and agree to answer or question any statement. Thank you.
Justice Tom C. Clark, writer of the dissenting opinion, in which I argue that the majority's opinion created an unnecessarily strict interpretation of the Fifth Amendment that curtails the ability of the police to effectively execute their duties. He wrote that the state should not have been burdened to prove that the suspect was aware of his rights during the interrogation, but that statements resulting from interrogation could not be automatically excluded if the suspect was not explicitly informed of his rights. In his separate dissenting opinion, Justice John M. Harlan wrote that the judicial precedent and legislative history surrounding the Fifth Amendment does not support the views that the Fifth Amendment prohibits all pressure on the suspect. He also argues that there was no legal precedent to support the requirement to specifically inform suspects of their rights. Justices Potter Stewart and Brian R. White joined in the dissent.
I am Justice White. I agree with the dissenting opinion, but for a different reason. I believe that with the Fifth Amendment, it only protects defendants from giving self-incriminating testimony if explicitly compelled to do so. I argue that custodial interrogation was not inherently coercive and did not require such a broad interpretation of the protections of the Fifth Amendment. Such an interpretation harms the criminal process by destroying the credibility of confessions.
1, 2, 3.